Okay, Joe, do you think we can start our meeting?
Good afternoon. Yes, Your Honor.
All right. Hello, everyone. I'm Joan Alexander. I'm very happy to be working with you on the Rules Committee. This is our first meeting for the year. And I think the first order of business, besides calling the meeting to order, is for Attorney Del Campo to call a roll call for our members.
Yes, Your Honor. Your Honor is here. Judge Aaron.
Here.
Judge Armada.
Present.
Judge Chaplin.
Here.
Judge Green.
Present.
Judge Matrowski. I believe she couldn't attend. Judge McLaughlin.
Here.
Judge Pearson.
Present.
Judge Stewart.
Here.
Thank you. You have a quorum, Your Honor.
All right, perfect. And again, I think consistent with the protocol, I'd ask that the committee members leave their cameras on. And I'm very happy and excited to be working with all of you. I know that we did not have a September meeting because we were in the process of changing chairs, but I'm looking forward again to working with all of you. With respect to it, our agenda first has the item of the approval of minutes, and obviously I was not chair and some of us were not members. So I'm going to again turn that over to Attorney Del Campo to see if the minutes are going to be approved, and if there's any discussion, I will be abstaining from that.
Yes, Your Honor. I believe those present could move to adopt the minutes. Someone will need to move.
So
One of the
moved,
members.
Judge Pearson.
Okay.
Chaplin.
And would there be any discussion? Hearing none. All those in favor?
Aye.
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 Any opposed? Abstentions? I'm sorry.
I'm going to abstain. I wasn't on the Rules Committee at the time.
Judge Aaron, Justice Alexander abstaining,
Yes.
and those are passed.
All right. Thank you. Thank you for doing the work without me. I appreciate it. And now we can move on to the agenda. And with respect to it, again, because I'm new, I'm going to be deferring a lot to Attorney Del Campo and the members who did participate, especially in some of these items that were on the agenda last year for discussions and proposals. So our first agenda item is 2023-011, and that is the AI programs, etc. And Attorney Del Campo, can you give us an update? And then I'd hear from any committee members if they have any discussion on this item.
Yes, Your Honor. 2023-011 was first proposed by Attorney Zalotes. That's now been teamed with the second one, which is 2023-014. That public act was adopted in 2023, and the committee has considered it initially. There is an informational memorandum in your files and additional comments or materials from the CBA. Judge Armada, I believe, has been tasked with kind of sort of aggregating all of this information for the committee. And he is here. I believe he may want to give an update.
So last year, when we took up this proposal, we reached out to the Connecticut Bar, who was creating its own task force to look at it. And they suggested that we hold off because the jurisdictions that were passing rules, they were finding out that the rules were quickly outdated as the technology was changing so fast. I think we have to move this to the forefront. I will note that Justice Alexander and myself are on a statewide committee from the branch on artificial intelligence in the court legal system. So I think we've got to take a look at what other jurisdictions are doing and what we want to encompass with these rules. But it's moving faster and quicker than I think we thought. But the Connecticut Bar is also willing to work with us in terms of helping us come up with rules and regulations.
Yeah, correct on that task force. We had, again, our first meeting, I believe last month. Our next meeting is going to be in November, or I can't remember the date. But we will be receiving a presentation from our judicial IT department, and we will also be hearing from the CBA as to their update. So hopefully we'll have more information. Would anyone else like to comment or discuss these items at this time? No? Okay.
Wait, actually,
Yes.
I just would add one thing. I was last year opposed to us doing anything for the reasons that have already been stated, but I'm still reluctant for us to be passing court rules on this issue, but I would like to bring to people's attention if they don't know it. The American Bar Association came out with a very lengthy formal opinion this summer, dated July 29th, 2024, and the formal opinion is number 512. It's entitled Generative Artificial Intelligence Tools, and basically it's extremely long. The theme of it is that the rules of professional responsibility deal with many of the issues that they're addressing here, the current rules. So just something to think about and to consider before we start drafting our own rules here.
Thank you. And do you have a link to that, Judge Stewart, or do you want to share that? Or is it too long?
It is 15 pages, single space long with many, many footnotes. I don't have a link handy, but I'm sure I could come up with one.
All right. And if you could give that to Attorney Del Campo, then the committee members could look at that material as well for consideration. Thank you.
You're welcome.
Anyone else wish to be heard on this, these matters? Okay. So Attorney Del Campo,
Excuse me, Your Honor, can I ask this, will this go over to a specific meeting, or I'm sorry if I didn't catch that, or if it's just going to be tabled until we bring it back?
My preference would be to table it. And again, I'd hear discussion on that simply because the AI committee task force, I think, has a fairly quick deadline to get some recommendations to judicial as a whole. And I would like to see what that task force comes up with, especially with the information from our IT people. Is there an agreement to that?
Yes, and that AI meeting is on November 13th,
Okay.
and our next rules committee is on the 18th, so we won't have time to process anything really.
Thank you. Thank you for checking the date.
Joe, I
Sorry.
posted a link for the panel in the chat.
A
Sorry,
link
the
to
question
the
is-
ABA?
Yeah, it's in the chat. I just posted it.
Thank you.
Thank you.
Thank you.
So I guess my question would be, are we tabling this to January to give us time to review these matters?
Right. I would say that it would at least be January. And again, we will try to digest what we're doing on the AI task force. And I'm sure our minutes will show up too. So you could always cross-reference that task force on the website.
Thank you.
With respect, so that took care of 014 as well. So 2024-001. Again, Attorney Del Campo, can you give us a status and an update on that agenda item?
Yes, Your Honor, this was previously on the agenda on February of 2020, February 26, 2024. It was originally submitted by Attorney James Sullivan. Was on the agenda as a first in January, then last in February of this year. At that time, the committee tabled a proposal to the September meeting, which is now this meeting, and asked Attorney Sullivan to work with the CBA on language to perhaps insert this into these principles into the preamble to the rules of professional conduct. I think you have in your files an update from Attorney Sullivan indicating that he did reach out to the CBA, but has not been informed of their opinion yet on the matter. He was invited. I don't see him as present.
No, I'm
at this
here.
meeting.
Joe.
Oh, I'm sorry. If the committee would like to hear from Attorney Sullivan, he is here.
Yeah, I've sought the feedback from this appropriate CBA committee, and I have not gotten anything back yet. I think one of the chairs has been ill, and that could be the reason for the delay, but I will again seek their feedback on this proposal. And I
So would
also
you-
would like to know, what the State Bar Council and the Chief Disciplinary Council think of this as well.
And did we hear anything from either of them, Attorney Del Campo?
No, we do not have materials from them.
So maybe
they
we
have-
can, have they been reached out to already?
Yes, they're on copy, I believe, but I can do that again, send them everything.
All right.
There's a note in the chat, I think
Yes.
relating to this discussion
Okay.
from Danielle Edwards.
Okay. Attorney Edwards, did you want to be heard?
Hi, Your Honor. Hello, everyone. Thank you for inviting me. I had been invited to the last meeting where this issue came up. I think it was in February last year, and it was tabled as just discussed for a bit more input. At that time, I just wanted to share that my co-chair, Jim Bergen, and I had polled the members of the Professionalism Committee, and if it's helpful, the majority of the members of the committee would like the principles to be published in the practice book, noting, of course, as the principles do state, that they have not been actually enacted by the courts and should not be the basis for any kind of tort action or other grievance type of action. The principles have been around for about 25 years. They've been written and guarded by this committee. And we undertook about a year-long project to rewrite them in 2019, and then in 2020 they were accepted by the CBA. These principles are provided in the materials of every event that the CBA produces. In 2020, when they were adopted, there was some discussion with the judicial branch that they may be also provided to pro se parties, and potentially made available in courtrooms as a reminder to all of the kind of decorum that we expect and that we hope and that we aspire to. If there's anything else that our committee can provide that would be helpful, we're more than happy to do so.
Great. Thank you very much.
And Your Honor, I'm sorry, I did misspeak. There are comments in your package from the Statewide Bar Council and Chief Disciplinary Counsel's office on this proposal. So those you can see in your packages.
All right. And with respect to it, do any of the committee members want to discuss this further, or would you like to review all of the material now and move this to our November meeting?
It looks like there may be another hand raised in the chat from Elizabeth Rowe.
Okay. I don't see it, but
Good afternoon, Your Honors. This is Elizabeth Rowe. I'm
okay.
with the Bar Council's office. I was invited. The Statewide Bar Council wasn't available for the meeting, so I'm here if you have any questions for me.
Do any of the members have questions for Bar Council? Thank you, Attorney Rowe.
I just wanted to ask, this is Judge McLaughlin. Attorney Rowe, I know I saw that the comments were that the Bar Council does not want the principles sort of codified, I'll say. But did they have a position with respect to it being part of a preamble in the practice book?
That was actually our suggestion in the comments that we sent, was that perhaps language should go in that area for this rule.
Thank you.
You're welcome.
Any other questions or comments? Was there anyone else invited, Attorney Del Campo? And I apologize, Attorney Rowe, I didn't realize you were invited.
I think Attorney Rowe is here for both of those offices, because Attorney Staines was invited as well.
Any further discussion from our committee members right now? So, with respect to this, should we be moving forward today, or should we move it until the November hearing and decide what, if any, proposal we would make? Any thoughts on that by the committee members? This is my first chairing, so I don't want to overstep and say, let's do it now. But go ahead, Judge McLaughlin.
I just had a question. I think it was Attorney Edwards said that, and maybe I missed it, but for language in the preamble that would include, I don't think we have a draft of something that would include the carve out that Attorney Edwards talked about, which is, you know, that this is sort of aspirational. It's not to be intended for any sanctionable conduct or something like that. I wasn't sure if we had a draft of language like that to consider.
Judge Green, is that your question as well?
Actually, my question was, it seems that there isn't support for it as a rule, but would inclusion in the preamble, would that be sufficient? So I think that's one, we don't have the language in front of us, but Attorney Sullivan is the one who proposed it. Maybe it's upfront inclusion in these materials would be helpful, but it would not be a rule.
Do you want to be heard, Attorney Sullivan?
I'm happy to draft some language, but I'm not sure it's necessary. Nobody has ever contended that this is going to be a rule that would give rise to discipline. And the way that it's drafted, they're clearly aspirational in nature.
Attorney Del Campo, do you and your team usually look at the final language and then circulate it for us to consider, or is this complete enough for us to take action on?
We can do that if that's what you would like us to do. Sometimes the proponent, sometimes you ask the proponent to get with the different entities who are interested, even including disciplinary counsel and statewide bar counsel. Sometimes there's an ad hoc committee of those individuals. It just depends. I mean, sometimes the proposals come here whole cloth, and sometimes they don't, quite honestly. So if the committee wants to have us draft it and review it, we certainly can do that. Or you can have you can actually have it meshed into the preamble by the proponents. Whatever you think is something you would like.
And Attorney Edwards, I see that you had another comment that you would like to make. You're on mute. Okay, we are not, but she did make a comment in the chat section that there is a limiting provision at the end of the principles. Do the committee members have a preference as to whether the proponents should provide the language to us or that Attorney Del Campo's team provides the language? Any preference? Hearing none, then
Judge Stewart has a question.
Oh, sorry. Go ahead.
Okay, before we get to that, I don't really even understand where this would go. I'm looking, I have to admit, I didn't ever know that there was any kind of preamble to the practice book. I'm seeing here that in the front of the book, besides explanatory notes in the table of contents, we go straight into the rules of professional conduct, which have their own preamble. So where exactly are we thinking of putting this? That would have some bearing on how it's written, it would seem to me.
Attorney Sullivan, I thought your proposal was right in the preamble.
Correct.
But there isn't a preamble except for part of the rules of professional conduct, and I don't think we can stick this in that. That's the problem I'm having.
The idea would be that it would go before the preamble to the rules of professional conduct.
So before even the explanatory notes and the table of contents for the whole thing, or?
It would go after that.
I mean, I just think it's a little odd that we have preamble and then we have rules of professional conduct preamble. Yeah, all right. Well,
So I will note, this is Judge Chaplin,
Yes.
looking at, and this is, I haven't handled 2023 practice book, so it may be different, but the first page has the attorney's oath and then the
yeah,
rules.
yeah.
Attorney Sullivan, was your intention to insert it between the oath and before the rules, or a different location?
No, that would be fine.
But I think to Judge Stewart's point, then there's a preamble. So it would be
Right.
attorney's oath, preamble, rules of professional conduct, preamble.
I mean,
So I think that
I'm
might
just
be a
a-
drafting.
To be clear, the way mine is printed, it has attorney's oath, then it goes to the rules, and under the rules heading is the preamble. And so I'm asking, is it intended to be before the rules, before the preamble begins? So it's a different question from Judge Stewart's question.
Well, I guess then my question would be, are we having two preambles within?
Right.
one of which is officially enacted and the other is not. I'm just really concerned about confusion here.
So perhaps we should come back another date once we have more clarification as to the proper positioning.
What I would do is, again, ask Attorney Del Campo to see if there's a spot that would not require, I guess, the official adoption of this as a rule, but that would make the most sense as to where it would be located. Is the printed volume considered or is the electronic volume? They're all going to look the same, right?
Yes, Your Honor. They'll all look the same.
Yeah, you never know. But with respect to it, why don't we put this over to November? We have a general idea of what we want to do. And again, if there's any finalized language that you would like to see, Attorney Sullivan or anyone from the bar committee, et cetera, please let Attorney Del Campo know. Hey, I think the next matter on our agenda is 2024-006. And Attorney Del Campo, again, can you give us a status?
Yes, Your Honor. This also was submitted by Attorney Sullivan. Actually, this is first time being considered, so you haven't seen this before. It is a proposal to amend Rule 1.15 of the Rules of Professional Conduct. And again, Attorney Sullivan is here, so if he would like to explain and you wanted to do so, she should do that.
Go ahead, Attorney Sullivan.
This proposal is in the wake of a decision called Office of Chief Disciplinary Counsel versus Enrico Vaccaro, where a lawyer was allowed to carry a balance of over $220,000 in his IOLTA account without any identified or known client. Massachusetts has adopted some rules that I think would benefit Connecticut, where there's several changes that could be made to 1.15 so that the Enrico Vaccaro decision would not happen. One of the changes would be to make the burden of proof not on the state, but on the attorney to prove where the funds are to be, who owns the funds and where they're supposed to go. The other change that would be made would be to require the lawyer who learns of any unclaimed or identified funds in their IOLTA account to make diligent efforts to locate and identify the owners of such funds. And there's a time limit for that, those diligent efforts. And finally, it would require the financial institutions to enter an IOLTA account inactivity notification agreement with the disciplinary authorities, under which, after 2.5 years of inactivity, the financial institutions would notify the lawyer that the account is inactive, and if an inactivity continues for 6 more months, the account will be reported to the disciplinary authorities.
I see in your letter that you did reach out to Attorney Staines and Attorney Slack. Did you hear back from either of them?
I did not, but I know that Attorney Staines did want to be heard regarding this.
And Attorney Del Campo, can we reach out to some of these individuals to see if they could submit comments? Or Attorney Rowe, I forget you're here.
That's okay.
Are you prepared to comment on this?
Yes,
Okay.
partially. The
Okay.
the Vaccaro decision is on appeal right now, and so it would be the position of our office that this is premature. We should wait and see what the appellate court does with that decision, and once we have that guidance from the appellate court, if we need to make changes to the rule, then we would sit down with the disciplinary counsel's office and propose rule changes and provide you with the rule citations and everything else. We do have a random audit program in Connecticut. We do go in to see what's going on in IOLTA accounts on a regular basis. Overdrafts are reported to our office. The disciplinary counsel's office does have trustees that go in when an attorney is deceased or retired, and they're allowed to let us do an audit and determine what's going on with the funds. And right now we do issue funds to the state of Connecticut. So if we were to do something different, which is, I think, a different proposal in Massachusetts, that would affect Department of Revenue Service. Or State Treasurer, sorry, State Treasurer.
Thank you. Do any of the committee members have questions or comments? Yes, Attorney Judge.
I don't know who's going. I have a concern just in terms of the letter from Attorney Sullivan in terms of requiring financial institution to file certain things. I think you've got to be very careful. These banks are holding IOLTA money, and if we make it difficult or cumbersome regulating in terms of things filing, and I think we need to get their input as well. Perhaps the best entity to do that is the Connecticut Bar Foundation, who works with collecting the IOLTA funds, and they can hear what the bank's position is, because that could have a chilling effect, I think.
Anyone else want to discuss this? Again, I am aware, like Attorney Rowe, that this matter is up on appeal. Is this something that we should table until the appellate decision has been issued? And we can keep track of that. Attorney Del Campo, is that, you're on mute?
Sorry, Your Honor. Yes, yes, to your question originally, typically you would refer these out. Attorney Rowe's office would likely be one of them. The CBA would be another entity. Attorney Staines' office would be another entity. You know, I suspect the comments you would get back are that it is on appeal. I mean, you could still refer it out and get their comments on what has transpired at this point. And then if it's still on appeal, certainly you can table it until its conclusion. So whatever are your wishes.
I guess we can send out a request for comments, but note that the case is on appeal. So if they wanted to hold or add additional comments after, we could notify them. But I guess we can start gathering the information now. Thank you. So that is, now we're at 2024-007. And again, Attorney Del Campo, if you can give us a status.
Yes, Your Honor. This also is the first time being considered. This is the first time the committee has seen this proposal. It is a proposal for a new rule to end what was termed racial discrimination during depositions. It was submitted by attorney John Spielman. He has been invited and is here to explain the proposal if you wish that he do so.
Yes, go ahead, Mr. Spielman.
Good afternoon, Attorney Del Campo, honorable members of the committee, and my fellow lawyers. I have a request for a new rule, practice book section 13-34, objections to deposition questions based on race, ethnicity, or skin color. On August 28, 1963, the Reverend Dr. Martin Luther King Jr. proclaimed, "I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin, but by the content of their character." It has been over 60 years now since Dr. King brought forth his bold vision for America. Sadly, his dream is still disrespected in some precincts today. Respectfully, Your Honors, the legal system and the racism that it permits must be reformed. It needs to ban attorneys from using a plaintiff's skin color to impugn the credibility of their character during depositions. No counsel should be allowed to set up sinister syllogisms for financial gain on behalf of their own client at the expense of an injured client of color. Consider the following syllogism and the deposition testimony from which it was based. All people get injured as a kid. Injuries cause bruising. David was once a kid. Now, grown-up David must have bruised from his slip and fall, yet David is unsure if he had bruised at all. Now listen to the actual deposition transcript. Question. All right now, bruising. Are you saying you had a bruise but you couldn't see it? Answer. Yes. Question. How do you know you had a bruise? Answer. I'm not sure I had a bruise because of the color of my skin. Question. Have you ever had a bruise that you could see? Answer, I can't recall. I've been injured so much in my life as a kid. Question, well, then you must have had a lot of bruises, right? Answer, no, I can't comprehend that one. Question, do you know if you had a bruise, it would be visible on your body? Answer, not necessarily, because I'm a black guy. During the deposition, this was the 3rd round of questioning about bruising and the color of the plaintiff's skin. 64 questions and 10 pages previously in the transcript, David Doe confirmed that he had trouble seeing bruising because of his complexion. That should have prevented this malignant line of inquiry. It is remarkable that bruising was never alleged as an injury in his lawsuit whatsoever. This genre of cross-examination completely distorts, discounts, and disrespects an injured client's perception of bruising based upon the color of their skin. Arguably, it presents the illusion of logic to imply that an injured client of color lacks credibility and therefore their claim should be worth less. At best, such cross-examination can be viewed as a ploy meant to depict an injured client of color as being overly sensitive, easily flustered, or downright confused by seemingly valid questions. This confusion could be mistaken as a lack of truthfulness in testifying. At worst, those questions can be seen as a shameless bully tactic meant to send an ominous warning. That warning, cross-examining counsel will make you, as an African-American male, look like a stereotypical angry black man in front of a jury. Such despicable racial questions rob an injured client of dignity and arguably dollars based upon the skin color. This is prejudicial in the truest sense of the word. That is so because it lays an improper foundation for a jury to later judge an injured client's credibility, not based upon character, but rather by the color of their skin and their reaction to unfair questions about the color of their skin. Wherefore, the undersigned counsel sincerely requests that the rules of practice be amended with a new rule Section 13-34 to prevent systemic racism during Connecticut depositions. Thank you.
Thank you, Attorney Spielman, and we do have that as written material as well. Would any of the committee members like to ask any questions or have any comments regarding this? Hearing none, I'm going to work with Attorney Del Campo and see if there's any additional stakeholders who we should reach out to before further discussion. And just because, again, I'm noting I'm a new chair, so I'm going to table this and then we can bring it back on once we've had this discussion, but I very much appreciate your submission, Attorney Spielman.
Thank you very much.
All right, we are now moving on to 2024-008, which is the board certified behavioral analyst matters in family court. And again, Attorney Del Campo, if you could bring us up to speed as to where we are and the commenting, etc.
Yes, Your Honor. This is another matter that's first time being considered. It's first time on your agenda. It was it's a proposal to amend Practice Book Section 2562 concerning GALs and family matters to include different types of board certified professionals. It was submitted by Ms. Christina Torres. She's a board certified behavioral analyst. She is in attendance. I believe.
Joe,
And
I'm
what-
sorry to interrupt again, but there's a comment from Ms. Torres asking if the matter could be passed until 3. If you just look in the chat section,
Okay.
you can see it.
It's Attorney Petrozelli speaking, just for the record. Your Honor, whatever your pleasure is, we can pass it. If you're still in session at 3, then you can go back to it. You're muted, Your Honor. Your Honor, I'm sorry, you're muted.
I forget the mute button. Yes, I agree with that. If we're still going at 3, hopefully Christina Torres can join us. If not, we will re-invite her in our November meeting, if that's acceptable to the members. Any further discussion or requests before we move on to the next matter? Right. Thank you. Whoops, next matter is 2024-009. And again, Attorney Del Campo.
On this one, Your Honor, I'll defer to Attorney Petrozelli. She did do some work on this particular item. She's assistant counsel.
Hi, Your Honor. I'm Lori Petrozelli, Assistant Counsel to the Rules Committee. In July 2024, as I'm sure Your Honor knows, our Supreme Court decided the case of Epright versus Liberty Mutual, in which the court held that Practice Book Section 13-4 was not reasonably clear enough to prohibit ex parte communications with another party's disclosed expert witness. In footnote 9 of that opinion, our Supreme Court called attention to the Rules Committee of the Superior Court, asking it to evaluate the propriety of ex parte communications with opposing parties' disclosed expert. Pursuant to this, Justice Andrew McDonald, who was the chair of the Rules Committee at the time, asked our office to conduct a 50-state survey to observe the trends in this particular topic. I conducted a 50-state survey, which is part of the materials submitted to the committee. Basically, the trends are that most states have modeled the rule after Federal Rule Civil Procedure 26. Our state did model its discovery rule after the federal rule until about 2009, I believe. The current status is that 30 states have a rule that contain a prohibition on ex parte communications, and we discern that either from the case law or the actual language, which basically said discovery can only be had, quote, only as follows. And then there were 20 states, including Connecticut, New York, Rhode Island, Maine, and Pennsylvania, that did not contain an explicit prohibition on ex parte communications. I'd like to call the committee's attention to one state, which is Idaho, which is the only state that had a very explicit standalone rule prohibiting ex parte communications with experts. And lastly, I wanted to call to the committee's attention that while other states did not have such an explicit rule as Idaho, there were some states that had explicit rules on prohibiting contact with healthcare providers who were identified and as disclosed expert witnesses.
Thank you very much for your research. It's very thorough and helpful. Again, because this is fairly new, does the committee think that we should be reaching out to different areas of practice to have them weigh in on this proposal slash note or footnote in a Supreme Court decision as to what action, if any, should be taken to our rules? Do anyone want to comment on that? And if so, I see Judge Pearson, who do you think it should go to?
I certainly think to the CTLA and also the Defense Lawyers Association.
Okay.
That's stating the obvious, but for sure.
Attorney Del Campo, do you have any other organizations that we would routinely send these to? Oops.
CBA, you normally send it to CBA, and the CAJs, I would suspect you want it to go to.
The civil CAJ or all?
Yeah. Well,
And family.
Family?
Civil and family, okay.
Does that take care of you, Judge Armada, or did you have additional comment?
Nope, that takes care of me. I was going to suggest those.
All right. Any other suggestions? And we'll certainly try to get some information and again, some comment on this because it was an unusual situation in EPRI, but at least we have a very good starting point with Attorney Petrozelli's survey of the 50 states. So again, timing wise, do you think this should go over until the beginning of next year to give people enough of a time to get back to us? I see a lot of nods, so I'll take that as an agreement. And once we start getting some of these comments back, we will put it back on our agenda. All right, we can move then on to, unless there's anything else, Attorney Del Campo, I'm going to go to 2024-010.
That's fine, Your Honor.
Okay.
Those items, well, I'm sorry, 2024-010, 2024-011 were both submitted by Attorney Daniel Healy. This is the first time the committee is hearing from them. They both concern criminal procedure. Typically, you would again refer them out, having been the first time you're seeing it. Judge Gold certainly would want to see them, and whomever else you feel is appropriate to refer those to.
Comments? We may be able to have a discussion with Judge Gold. One of the things that concerned me in proposal at least 10 is that the arbitrary 5 court appearances would not be consistent, I don't think, statewide in criminal courts. You know, what a continuance is in Bridgeport versus Waterbury may be very different. And there is also obviously legislation as well as practice book rules that specify amount of time in order to claim a trial case or a speedy trial. So we may be running into a few difficulties in just drafting a rule, even though it seems fairly straightforward. Judge Armada?
Does it make sense to also refer to the Office of the State's Attorney as well as the Chief Public Defender for comment?
I think we should probably start a little bit with us investigating it in out of Attorney Del Campo's office about the rules that are and legislation and statutes that are already in place regarding this. And if we see that there is a need for further comment because we are considering that, then I would go to the state's attorneys and the public defenders, as well as like the defense attorneys, private bar association. Okay. But at this point, we will mark this over, and I'll have Joe, Attorney Del Campo, reach out to Judge Gold, and maybe again your office can help us with finding the rules and the statutes that go along with speedy trial and jury claim forms. The form, obviously, in 2024-011 was the civil form. And again, that's really not consistent with the criminal practice because it's generally a motion for a speedy trial that we have used as our rule. So we will table that until we get a little more information.
Thank you.
With respect to 2024-12, again, do you want to bring us up? This is the first time being considered.
Yes, Your Honor. Attorney Petrozelli will take that one. She will explain to you. This is more of a housekeeping matter. The way we found it, we go through the practice book year end at the editorial process and during the publication process, and we sometimes find issues. This was one that Attorney Petrozelli did find, and we did go to Judge Wynn O'Dowd to make certain that additional changes to the practice book weren't necessary, but Attorney Petrozelli can explain a little more.
Yeah, Joe, I think you very well summarized it. As part of the process where we go through the practice book, each year we update the statutes noted table, and that brought to our attention that section 26. I'm sorry.
Okay.
I didn't know, Dane, but
No, that
heard
was, I
voice
think,
in the
just an
background.
errant. That was just an
okay.
errant comment, I think.
Oh,
Good.
okay. So as part of the process, we go through the statutes noted table in the practice book, and it came to our attention that there was a statute that was cited in practice book 26-1 that was repealed, that being 46B-149. We already checked with Judge Wynn O'Dowd to make sure that there wasn't any substitute statute, and there was not. So we're just submitting just a simple matter for the committee for permission to remove the repealed statute from subsection O of 26-1.
All right, thank you. Any discussion on making that change? Seeing none, I think we have to move for this. Is that correct, Attorney Del Campo?
Yes, Your Honor.
Right,
So moved.
thank you. Any discussion?
Second.
All right. All in favor, aye?
Aye.
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 All right,
Aye.
any opposed? I think it passes. This is my first official being passed. That's it. I should stop now while I'm ahead.
Good job.
And I think, Your Honor, and Lori could correct me, but I think this is a technical change. I think we consider this a technical change. We did go to Judge Wynn O'Dowd to make certain there wasn't any other substantive changes that needed to be made, but I think this is not something that would typically go to the judges at the end of the year. We would just do that through the reporter's office.
That's fine with me.
Okay.
So Joe, if possible, do you want me to see if the reporter's office can get into this year's book?
Yes, if we're still in that editorial process,
we're kind of hitting up against the deadline,
Okay.
so
Right.
I'll find out for you.
Okay. Thanks.
Okay, thank you.
Okay, and our other matter is 2024-013. Again, if you could give us a summary.
Well, again, as you've noticed, typically the first meeting of the year is a lot of items that you haven't seen before. This is another one. This was submitted on behalf of, submitted by Attorney Shea on behalf of multiple legal service agencies. Attorney Shea, I believe, is here, Giovanna Shea.
Would you like to comment? Oh, I think you're on mute. No, we can't hear you.
Seems that she's in attendance, but her microphone is on.
Right.
I can't hear.
Are you able to, we still are unable to hear you.
She wrote in the chat that she's sorry she'll leave and rejoin the meeting to try to get back on. In any event, this is a matter that is, I'm sure she'll come back on and explain it more fully. But again, this is a matter that you seeing for the first time, you would typically refer it out to Judge Bellis, the CBA, and any other individuals that you think are appropriate, court operations perhaps, in judicial.
Okay. Any other groups that our members can think of besides what Joe has just run down? And we'll see if Attorney Shea comes back on. If not, obviously she'll have time.
She is, Your Honor. She is on.
Okay, let's see.
Justice Alexander, can you hear me now?
Yes, perfect.
Okay, all right. Thank you so much. Sorry about that.
Not a problem.
So this is the first time this has come before the committee. Just by way of context, it's a proposal from the 6 legal services organizations that provide eviction defense through the Right to Counsel program, plus 2 others that provide eviction defense more generally. As members of the committee may be aware, it's a very compressed timeline in summary process. The regular discovery rules do apply, but as this committee is aware, it's a 60-day response time. The proposal is to reduce that response time for interrogatories and requests for production to 15 days to better match the speed and timeline of summary process, because many of these cases are done in 60 days. And a second part of the proposal really would additionally benefit unrepresented folks, and it is a mandatory disclosure proposal. Those who sat in the housing session and others probably are aware that the vast majority of these cases are resolved in mediation. The mandatory disclosure proposal would be that no case would go to mediation or trial without disclosure of the lease and ledger. And so we think that would help unrepresented people, so they would not be placed in the position of attempting to reach a stipulated agreement that would be entered as a court order without being able to look at the ledger, contest the amounts on it, see the lease, see the attorney's fees provision on the lease if there is one, and that sort of thing. Even with right to counsel, the vast majority of tenants remain unrepresented in the housing session. So we think that kind of mandatory disclosure is important for those who can't use or who are less likely to use formal discovery rules. We did bring the mandatory disclosure proposal to Judge Bellis as a proposal for a standing order in the spring, but she thought it was more appropriate to come to this committee. And then we also added the suggestion that the timeline for objecting or responding to discovery be short. So I'm happy to answer questions if folks have any questions, but I understand it will likely be sent out for comment, as is customary.
Does anyone have any questions for Attorney Shea? Right. When you were logging off and logging back in, Attorney Del Campo gave us a list of people he would send out your proposal to, so we can have the comments. And again, so that we give enough time, my suggestion would be that it go, I don't know if we have a December meeting or if we skip December and then do January.
We do have December, Your Honor, December 16th.
Do you think it's overly ambitious to get comments by December from some of these groups?
No, I mean, well, Judge Bella certainly has seen it before, heard it before. Court operations is very timely with their comments generally, and you know, the CBA, I'm not sure. They do have a liaison that works with them, but that sometimes is a little harder depending on the dates that the different committees meet and the attorney schedules. Certainly.
So my preference would be, again, because of the importance of this tool, a lot of litigants in the housing matters, that we do it as quickly and realistically. So if we could shoot for having their comments in by December, I think that would be appropriate. Did you want to say something else, Attorney Shea?
I will just note that the committee might consider seeking comments from the Connecticut Advisory Council on Housing Matters, which is a statutory body set up by 47A 71A, which is statutorily required to reflect a balance of the interests of tenants and landlords in its representation. The one fly in the ointment there is that their next meeting is December 18th, which is poorly timed given this committee's next meeting of December 16th. So I don't know if the committee would like to get all the comments that it can and then put this on for January, or how you'd like to handle that. But I thought I would mention that as an option.
Does the committee think that organization, we should hear from that organization given the description? I think it might be appropriate. And I do think then we'd have to go into January. I was trying to expedite this a little for you because I see what you're outlining. And I appreciate that Judge Bellis thought this would be a better referral to the Rules Committee. So we will move it to January and we will add that other organization for commenting. Thank you.
Thank you.
All right. And with respect to it, I don't know if Christina Torres has been able to join us. But if there's any other matters that anyone needs to bring up at this time.
I'm here.
Oh, okay. Very good.
Yeah, I'm not sure exactly how this process works.
Okay.
So I was Go ahead.
Okay, if you turn on your camera, that's perfect. All right. If you don't have to read what you sent us because we will consider it. But if you had any additional comments that were not included in your written material and you'd like to present that to the committee, please do so.
I don't have additional comments, but I'm very passionate about getting us established as providers qualified to serve as guardian ad litems.
Okay. Do any of the committee members have any questions of Ms. Torres? Okay, and Attorney Del Campo. Oh,
I had one question. Yes. Sorry, Justice Alexander. So this is Judge McLaughlin. So Ms. Torres, I just had, and this is just for me, I'm sure I'm not 100% understanding, but so when you say board certified behavioral analysts, who is the board? Who is certifying the behavioral analysts?
Yes, we are certified underneath the BACB, which is the Behavior Analyst Certification Board. There's 3 boards to become certified as behavioral analyst, and the BACB is the one in America. And then there's the International Behavior Analyst, and then there is also the qualified applied behavior analyst. Behavior analysis is a branch of psychology.
And that's my other question. So, but it's not, if I'm reading all your comments and your materials that you provided to us, so they're not overseen though by the Connecticut Department of Public Health.
No, but we do have to get licensed. We are licensed within the state.
Okay. All right, those were just my questions. Thank you.
Thank you.
Thank you, Judge McLaughlin. Attorney Del Campo.
Yes, sir.
Go ahead.
Oh, no, I was going to say typically, this would probably go out to, Judge Diana as the Chief Administrative Judge and Family. And, there's a standing committee on GALs and AMCs that meets regularly, that is, part of judicial. So you may like it to go to those.
All right, Judge Stewart, you had your hand raised. You're on mute.
Unmute myself. I just had a follow on to Judge McLaughlin's question. So if we were going to rewrite the rule, we would have to say, or is a mental health professional, or are you encompassed within that? Would you consider yourself encompassed within that category?
Yes, I believe
Okay,
so.
and then right now, as Judge McLaughlin pointed out, it says licensed by the Connecticut Department of Public Health. So you may have answered her question and said who it is you are licensed by that we would have to add into this rule. So I'm just trying to understand what that is.
So we are licensed. I'm sorry. We are licensed. We do have to get licensed with the state.
Okay, do you know what agency of the state?
I'm not sure exactly, but I know that we have to get licensed in order to practice here in Connecticut.
If you could provide us with that information where your license is issued, what state agency, that would be very helpful to our committee. And again, you can send it in via an email so we get that information, but we do need to know that. Do you have anything further, Judge Stewart?
No, those were my questions. I think Judge Armada has his hand.
Right, I see that. Judge Armada?
Yeah, I'd like to also refer it out to the Connecticut Bar Association Family Law section for comment.
That's,
yeah,
yes.
We are licensed through the Public Health, the state of Connecticut Department of Public Health.
Okay.
Oh, okay.
Yes,
All right. Any other questions? All right, what we will do, okay, I'm sorry.
And just to clarify, the proposal, is it limited to family court or is it to criminal court and other in juvenile court? Just trying to clarify the request.
Okay.
Ms. Torres.
Oh, I'm sorry. Honestly, it would be to serve as a guardian ad litem for the children. So family courts, I'm assuming.
The request is to amend Practice Book Rule 25-62B1, which is in the family section.
Right.
Yeah. And it would just be to add behavioral analysts after licensed clinical social worker.
Thank you.
All right, so we will send out your proposal for comments to the different organizations that you hear we've talked about, and we will put this back on. Again, is it overly ambitious to say December on something like this, or Joe?
No, I believe that's fine, Your Honor.
Okay. So this will appear on our December meeting again, and you'll receive notice of that meeting.
Thank you so much.
Is there anything else, Attorney Del Campo, that I've missed?
No, Your Honor.
Okay, I really appreciate all the help that the seasoned veterans gave me as a new chair, and I look forward to working with you. And I think then I have to adjourn this meeting. Is that the, I've only learned a few words in this whole process, but adjourn?
Yes.
Do I have a motion?
Yes.
Yes?
So moved.
All right. Second?
Second.
All right. Is that it? Have I, anything else, Attorney Del Campo, before I have a sign off here?
No, Your Honor. Thank you.
All right. Thank you so much. Have a great day, everyone. Bye-bye.
Bye.
Thank you.